An April 18th Ontario Superior Court decision that found marijuana cultivation and usage laws unconstitutional has been appealed by the federal government. Now, the court's ruling had given the government 90 days to respond with new regulations that met the court's criteria or to appeal the decision. Now, we spoke with Michael Kaer, a local resident who is licensed by Health Canada to legally use marijuana for medicinal purposes, about the court ruling and how the current regulations that are being challenged affect him.
This card here is basically what they call a get out of jail free card. Many people would like to get that card, and it's very difficult. You have to jump through so many hoops. You have to have all the forms signed, dotted. Everything has to be perfect. If you're not growing and you have somebody else as a designated grower, they have to go through the hassle of getting the security check, and then they have to sign their forms, and everything has to come together all at the same time and all be sent in all at the same time. And then there's deadlines that the paperwork has to be in on. If there's any problems, it gets sent back and you basically get sent to the bottom of the pile again. And that pile has actually grown larger and larger. There was a waiting time of several months. That's unacceptable for people who have cancer, AIDS, HIV problems, any illness that can be helped or treated with cannabis. These people are in pain on a regular basis, and the delays are just insane.
Now, Michael says it's not just the wording of the medical marijuana access regulation laws that make it difficult for users like himself and others, but the prevalent attitudes amongst local law enforcement officials who aren't always up to date on the legislation or familiar with its application when it comes to exemption from prosecution for medical use.
The fact that I have to go through all this hassle to be legal is a waste of my time, a waste of everybody's time. And on top of all this, a police officer could come to my door and bust me, even if I showed him the card, if he doesn't know that the card exists or that the law is set up for me to do things legally. Out of ignorance, he would just say, "Oh, you're smoking dope, and I'm going to bust you." People have actually gone through that process. They're trying to get help from the police, and they turn around and they end up being the victims. So I don't like the way the system is set up, where not only the doctors are not being properly educated, but the police officers are not fully educated. And there's a whole huge problem with that.
Now, the ruling was based on the constitutional challenge of Matthew Myrna, who relies on medical marijuana to ease his pain from fibromyalgia, scoliosis, seizures, and depression.
I am only one of about 5,000 people in all of Canada that have this card, which allows me to legally possess and smoke cannabis as a medicine. And I need it because I have peripheral neuropathy and other chronic pain and nausea. The first thing in the morning, if I don't have the medicine in me, I am violently ill.
Now, Health Canada's medical marijuana program regulates and approves the growers from whom patients can buy and how much they're legally allowed to use for their treatment. According to Health Canada, there's only about 5,600 Canadians with a license to grow for medical use, and another 1,800 or so with licenses to grow cannabis for someone else's use. Now, the Ontario Court of Appeal has recognized previously that to deprive somebody with a serious illness of medical marijuana, if it relieves their pain, is a violation of their charter rights, which is what led to the inception of the current medical marijuana access regulations in the first place. Now, Judge Justice Donald Taliano noted in his ruling in this case that the current regulations still force some seriously ill people to obtain marijuana illegally, or are preventative, as they may be unable to get a recommendation from their doctor, if they even have a family doctor at all.
Ever since the Parker case in 2000, the judge made a ruling that essentially the law around cannabis was repealed or dropped, or I'm not sure what you want to call it. It's null and void. the law does not exist. Now, for some reason, the government of the day felt that if they made up these regulations and found a way of being able to get medical cannabis to patients somehow, in the very minimal amount and way that they could, they figured that would, kind of either bring the law back or have some sort of framework to do that.
Now, don't put that in your pipe and smoke it just yet. Unless you're one of the only 5,600 Canadians with an exemption from Health Canada for medical use, police will still be continuing to prosecute marijuana possession and cultivation as always until a more definitive ruling from the courts in response to the federal government's appeal of this decision. For TV Cogeco, I'm Dave Parkinson.